Good morning, everyone. I would like to welcome Debra Schuster today, who has practiced elder law, disability law since 1999. And she focuses on elder law issues, special needs issues, elder and family mediation. And today she's going to talk about money. So please welcome Debbie Schuster.
Thank you so much, Judith. Thank you all for joining today. I appreciate it. So having to talk about money can be one of the most difficult things for anyone to do in any relationship, but particularly parents with their adult children. So we're going to talk today about what are these fears about discussing money? When is the right time to have this discussion? What do you just do to ensure that your wishes are followed? What types of documents are we talking about, which we'll talk about extensively? And what do you do with those documents once they're created? So, unfortunately, as human beings, we often don't like to confront difficult subjects head on. So, burying your head in the sand does not do any good because it doesn't solve anything. We've all heard about, family dysfunction, put the fun in dysfunction. Every family has some sticking point, and often it's about money. There are questions always that, if people go to the expense and the trouble and the efforts to create these documents, will they be accepted by banks and financial institutions, and for how long? People say, what do I do with them now that I've got them? All too often, people put them on a shelf and forget about them. The most significant question, which we'll talk about, is how do you choose and who do you choose your appointees? And of course, the perennial question, do I really need an attorney for this? Yes, you do. So what are the fears about discussing money? Clearly, loss of autonomy. People do not like, especially giving up the ability to control the money that you've worked for, inherited, is very frightening. The children, concerns that your children will assume that you're ill or worse, and or that you have some loss of capacity or recent diagnosis. Not knowing who to name. There are so many people that I meet with. Thankfully, they come into the office, but they say, I don't know who to name. I don't know if I should appoint my children. I'm not sure that they're going to have time. I don't want to be a burden. And ultimately, the ability to trust the people that you've appointed. Everyone wants to believe and inherently does trust their children most often, but it's frightening. It's very threatening to potentially give up that control. Many people don't want their children to know how much money they have or don't have. And it can lead to difficult discussions, but they're so important. And that ultimately concerns that your wishes will not be followed. And so you've gone again to all this trouble to create the documents, but they won't actually be adhered to. So when is the right time to talk about these issues? Now, before there is a crisis. Everyone over the age of 18 needs durable powers of attorney. So we're talking today about money, but the companion, and that I actually talk most often about, are healthcare durable powers of attorney and living wills, when combined, are called a healthcare directive. So that is absolutely an essential component of this advanced directive, durable power of attorney planning. Everyone over the age of 18 needs these documents if they have the capacity to create them, because once you're 18, you're magically an adult, even though you may not be acting like it, even though your parents or grandparents may be paying for everything. So it's very often a very good segue, if it's difficult to broach the subject head on with adult children, to say, I was reading in AARP magazine, or I saw a news piece about Susie Orman said that everyone, once they turn 18, needs a power of attorney for healthcare, because as a parent or grandparent, you have no authority to discuss with an 18-year-old healthcare providers or financial entities anything about their financial or healthcare issues unless they give you the authority to do that. And the issue is when my children went to college at 18, I paid for their cell phone, their rent, their car insurance, everything. And I said, look, if you want me to continue to do that, and if you call me up and say, Mom, can you talk to my landlord? Can you talk to my cell phone company? I need you to give me that authority. So very often I'll suggest to clients they have, that 18-year-old clients, that they have the document become effective immediately so that the parent or the individual who's financially responsible for them can talk to those financial entities. So being proactive allows for questions and more rational decision-making than in a crisis situation. So ensuring that your wishes are met are having candid and frequent discussions, bringing this up so that it becomes a normalized conversation. You must ask your appointees if they are willing to serve before you name them, because the other issue I see very often is an individual becoming incapacitated, which is one of the ways that the financial durable power of attorney can spring into being, allowing the appointee named under the document to begin to act. But the individual who's sitting in my office said, I had no idea that Aunt Louise was going to appoint me. She never asked me. And even though someone's appointed, they do not have to serve. There's nothing that legally requires them to serve, even if they sign an acknowledgement. Certain situations change. So you need to make sure that your appointees are willing to serve. And ultimately, creating legal documents and designations on your assets that express your wishes are the best way to ensure that they'll be followed. So what documents are we talking about? What designations are we talking about to have this conversation and to ensure that your wishes are being met? The first is the durable power of attorney. The second is a last will and testament. I'm going to talk about all of these. Beneficiary designations of various sorts to ensure that your assets do not go into probate, because it is unfortunately not well known that if you have a last will and testament, it does not keep anything out of probate. You have to have beneficiary designations. We'll talk more about that. And then ultimately, not everyone, but many people consider drafting a trust. And we'll talk more about the various types of trusts that exist. But these are the essential financial legal documents to ensure that you can express your wishes and identify who you want to make these decisions if you become unable to handle your financial decision making. So the first document is the durable power of attorney, and just some definitions. The principal is you, the person who's creating the document. The person that is appointed under the document is called the attorney in fact or agent. Decision makers under durable powers of attorney have authority over assets and other financial decisions that are in your name. So IRAs, real estate, bank accounts. If someone has a trust, the trustee is the individual who has authority to make decisions over assets that are titled in the name of the trust, and we'll talk more about that. But for most people, particularly if they do not have a trust, this means everything financially that they own, and the ability to enter into contracts for goods and services they may need, to respond to mail, to file lawsuits on their behalf, anything that could possibly involve financial issues. Spouses only have decision-making authority over assets that are either jointly titled or that they have been given the authority through a durable power of attorney to make decisions regarding the other spouse. This is not automatic. You have to give your spouse authority if you want them to be able to make financial decisions for you. And real estate is an odd creature. It is owned by a married couple in an indivisible one-half interest. So if someone becomes incapacitated and there's a need to refinance the house or sell the house or get a mortgage or a home equity loan, the non-incapacitated spouse has to be authorized through a durable power of attorney to act by signing the spouse's name. And if that authority is not given, someone will have to go to court and be appointed by the court to be able to do that. So yet again, another reason to create durable powers of attorney. So these are the statutory sections that pertain to the Missouri and Illinois laws enabling people to create powers of attorney. And it's very important to know that many people think that lawyers just create boilerplate documents and it's check in the box, and that may be true for certain things. but you can actually delegate whatever scope of financial decision-making you're comfortable with. There are many people that I have that want to delegate daily bill paying and routine financial transactions to someone, but want to leave decisions regarding investments and larger asset transactions to someone else. And you can certainly do that. So there are two types of durable powers of attorney. One is a document that becomes effective immediately upon signing. And again, this is based on the terms of the document. Or there's one that springs into being. Usually I recommend that the document becomes effective if you have someone that is already handling your finances, helping you with bill paying. And it doesn't mean you're incapacitated. It could be because someone has a fine motor issue, or it's just they don't want to be bothered with handling their finances because they want their adult child to pay everything online if possible, and they're just not as comfortable with that. So in those situations, I would make the document effective immediately. Routinely, though, my recommendation is that people make the document springing, meaning that the terms of the document specify when it comes into being, or the authority of the appointee under the document becomes effective. And that's usually when their physician, when the principal's attending physician determines that they're incapacitated, unable to understand financial transactions. And most often it is when someone develops some cognitive issue, and their executive function, their ability to comprehend, if I write a check or pay a bill, it will take money out of my checking account. Or if someone cannot really comprehend the value of their assets anymore. And that's really usually when there's going to be a prolonged period of incapacity. Because if somebody goes in for surgery or has a period of convalescence in a assisted or rehab center, it's usually not necessary to have someone take over their financial decision-making for a prolonged period of time, but it may be because it may be logistically not feasible to be able to get to a bank or even online bill paying. So in both Missouri and Illinois, again, you can choose whatever financial scope of decision-making authority you want to delegate over certain accounts or areas of financial decision-making. And these are the most typical: banking, check writing, real estate, access to safety deposit boxes, although we'll talk about, because I don't think safety deposit boxes are as secure as they once were. Investments, gifting or transferring assets, and that is with a huge caveat. Entering into contracts, loaning and borrowing money, that's another big red flag one for me. Creating, amending, funding, and revoking a trust, and making and changing beneficiary and survivor designations. Certain of these powers can only be designated if can only be delegated if they're specified in the document. So those powers that must be specified in order to delegate them to someone are the authority of your agent, attorney in fact, to change or designate beneficiaries, the power to make gifts or transfer assets out of your name, the power to create, amend, or revoke a trust agreement, and appoint successor decision makers. And there's good reasons to have these powers, but it's really, really important to understand the consequences of these areas of authority. You cannot delegate the ability to create a last will and testament. And again, the durable power of attorney only governs assets in your name. So let's talk about designating or changing beneficiaries. If someone goes to the trouble of naming beneficiaries on their various assets and accounts, which we'll talk about, or has created a trust, I recommend that you allow your agent to only make beneficiary designations on an asset that may lack those designations consistent with those you already have in place. So it's not to change them or to give an asset of yours to someone else. It's to make sure that your estate plan is consistent to avoid an asset from going into probate when you die. Power to make gifts can have very unintended consequences if someone ever needs Medicaid to pay for skilled nursing care. And that is an enormous area that I practice in, Medicare and Medicaid planning, particularly for seniors or individuals who have special needs. So if you transfer assets out of your name or your appointee does, that can have the effect of rendering you ineligible for Medicaid within 5 years of that transfer without specifically talking to an elder law attorney. So you don't want to necessarily give that unfettered power. The power to create, amend, or revoke a trust agreement. I mean, that should be carefully considered to whom you give that authority. And I always do recommend the ability, allowing your agent to appoint successor decision makers if for some reason one of your appointed agents becomes unable or unwilling or refuses to serve. So who is appointed is the most important decision of all. More financial exploitation occurs through individuals appointed under durable powers of attorney. Unfortunately, that is a statistic, and it is proven true over the past 20 years. So one's appointee should be chosen based on their skill set, not based upon who's your eldest child, because that may not be the person who has the best skill set to handle your finances or who you trust the most. They need to be financially secure and self-sufficient themselves and not susceptible to a predatory relationship or someone saying, oh, you can borrow $5,000 from your mom. I know you'll pay it back. That's not a good recipe for success. Has the time to devote to serving in this area, is detail-oriented and responds timely. And again, skill set is what's important. We all have different skill sets. You may have a child or person you want to appoint who's better at healthcare decision-making, and someone who is better at financial decision-making. And you can appoint the same person to make those, two categories of decision-making, but it's not necessary. You can bifurcate who is going to make those decisions. You always should name at least 2 appointees with the ability to name a successor, because if you name just one person and that person becomes ill or unable to serve, you're left without anyone. And that is the issue that leads most often to people needing to have someone appointed by the court, and you want to avoid the court whenever possible. And this is the least expensive and least emotionally stressful way of doing that, creating these documents. And transparency is very, very important. If you appoint some of your children, but not all of them, in these successive decision-making roles, I always recommend that whoever is serving provide copies of all bank statements, copies of checks, and evidence of the bills that they're paying every month to all of your children so that everyone knows what's going on, and there really reduces the likelihood of disputes or questions about how is dad's money being spent. So it protects you in that it increases the likelihood that no one's going to challenge the person you've appointed, and it protects the decision maker. Any questions about durable powers of attorney? Okay. Hearing none.
If you can, I just want to mention, if you do have anything, you could raise your hand and I will track and let Debbie know that you have a question. So, or type something in the chat.
So let's talk about the last will and testament. So let me back up, I'm sorry. The durable power of attorney for financial matters that we just discussed and the durable power of attorney for healthcare terminate upon death. So they become effective most often, again, upon a determination of incapacity by your physician, but they expire upon death. So that is when your last will and testament, the persons appointed under that document, would be able to act to distribute your assets to the individuals that you've named as wanting to inherit your assets and personal property, and to handle, last expenses of an illness, any remaining debts that have gone unpaid, etc. So it governs the disposition of property that is in your name that has no beneficiary designation. Because again, beneficiary designations that we'll talk about control how things will pass directly to the individuals that you've named as beneficiaries on assets. The will basically is a catch-all for assets that lack beneficiary designations that would have to go through probate in one way or another. So a will does not dispose of jointly held property if the other joint tenant survives. So if you own property with a sibling or with an adult child or with a spouse, and that surviving individual will inherit that jointly titled property. And if after that person dies, there's no beneficiary designation, that asset will end up in probate. Other titled property that has beneficiary designations, the will does not dispose of, because beneficiary designations control. That is the best way to keep things out of probate. Again, things with beneficiary designations are not handled by a will, and also trust assets that are titled in the name of a trust, or upon death transfer to a trust. A will does not dispose of. A will is really designed to address personal property and assets that lack beneficiary designations, so that they will flow to the people you've identified and in what percentages under your will. So you designate beneficiaries. Those are the people that you want to inherit property under your will. The personal representative is the individual that you name to handle all of this, who collects your assets upon death, pays expenses and claims, and distributes remaining assets to your beneficiaries. You can also name a guardian for minor children and disabled children under your last will and testament. You can't force the court to appoint them, and it doesn't avoid a hearing. But if you have disabled children that you are already guardian for, or grandchildren, and a parent is out of the picture, you can nominate who you want the court to appoint. And of course, you can have certain instructions for distribution of property, how much or what percentage you want someone to inherit and who you want to inherit. The disadvantages of the will is it does not allow descriptive or detailed instructions unless you create a very particular type of trust under your will called a testamentary trust, which we'll talk about later. And again, it does not avoid probate. So again, if you don't have beneficiary designations on your assets, your will ultimately will handle that, but all of your assets will have to go into probate. And probate, for those of you that do not know, is a particular division of every circuit court in every county that specifically handles issues pertaining to incapacity and distribution of property. So assets that lack beneficiary designations that are valued either individually or cumulatively of $40,000 or greater would require the opening of a full probate estate, which means that it would take about 9 months to go through the court system. Fortunately, in the will, it can say that you want no bond, and you can ask that the court allow your estate to be independently supervised, which significantly reduces costs and the administrative burden on your personal representative. For assets that are individually or cumulatively valued at less than $40,000, that is a small estate. That is a much more abbreviated process. So, there may be a life insurance policy or a CD or unclaimed property that doesn't have a beneficiary designation because you just didn't know about it. And most often that hopefully would pass through a small estate process unless the cash surrender value or the death benefit of the life insurance policy is in excess of $40,000. So one of the solutions is to create a trust, which we'll talk about later. A pour-over will is a unique type of will that is the companion document to a trust. So you always need a will because, again, if you have forgotten to name a beneficiary of an asset to a trust that you've created, or you forgot to title something in the name of your trust, the will serve, excuse the sports analogy, but it's almost baseball season, as a catcher's mitt to pour that asset over into your trust. So it's needed when your trust is created to transfer assets that lack beneficiary designations. And it still requires that those assets go through probate to pour into the trust, but they will specifically follow the detailed instructions that you have in your trust. And it requires that it have all of the other provisions of a standalone will. So let's talk about jointly titled property. Joint property automatically passes to the survivor named on the asset upon the death of the first named owner. If all named owners have died, the asset will need to be probated. And again, provisions in the will are ineffective as to joint property. It looks like there is a question. Judith?
Yes, there's a question. Should we take notes or will we get the slides?
Yes,
We
you'll
will
get that.
we'll get the slides and I'll send them to you in an email. And this is recorded, so you can watch again on our website, and I can send you that link.
Thank you. So what are the risks of relying solely on joint ownership, meaning not having a will? It gives the individual who is named on the joint account, meaning their name is on the account now, not after death. It gives them unrestricted account access. This is something I'm always concerned about when people have adult children and they put their adult child's name on their account, because that means that individual has unfettered access to those funds. And even though that is often a convenient or inexpensive way of estate planning that people assume they don't need to have durable powers of attorney, which is not true, because joint ownership just pertains to that account. It means that the person that may be acting under a durable power of attorney for you, that is joint account access, instead of having the account upon your incapacity named Debra Schuster, attorney in fact for, my mother, it means that I'm not acting in a representative capacity. I have ownership rights. So if that person is sued, those funds are potentially accessible in a lawsuit or in a divorce proceeding. And that is certainly not what most people want. Under a durable power of attorney, that is not the case, because the appointees under your documents are acting in a representative capacity for you. If they're a joint owner, they have unfettered access. Assets would pass outside of an estate plan. So if they have joint access, if they're named as a joint owner and they die, and you have died, that asset will not pass to perhaps your intended beneficiaries. It would pass into the estate of the joint owner. And again, it requires probate if both owners die. So you may have heard of transfer upon death and pay upon death designations. Those are types of beneficiary designations. TOD, transfer upon death designations, pertain to motor vehicles, trailers, boats, aircraft, stocks and bonds. Pay upon death provisions pertain to checking and savings accounts and certificates of deposit. To put a pay upon death designation on a bank account, checking, savings, money market, you have to go into a branch of your bank or financial institution, and there is a pay upon death card or form that you must sign that allows you to name who you want to inherit that account upon death if you still own it. A transfer upon death designation requires that you take the original title to whatever item of personal property, motor vehicle, trailer, boat, airplane, into any of the Department of Motor Vehicle offices, and they have a transfer upon death form that allows you to designate who you want to inherit that item upon death, and your title will be reissued in your name with the name of the transferee. How it works. This can be changed at any time during the owner's life. So even if you become incapacitated, one of the areas of authority that I advise people to be sure that their appointees know, and I have a checklist of instructions for your appointees, is that when someone becomes incapacitated, for them to immediately review what all your beneficiary designations are to make sure there is nothing that can be identified that lacks a beneficiary designation, again, consistent with your estate plan. Pay upon death, transfer upon death designations avoid probate if the people named survive you. It automatically passes to the recipient upon death. It's not required to go through probate. And again, the beauty of it is that named individuals have access to the asset only after the owner's death. So they cannot access or claim any sort of ownership during your lifetime. So what are the risks? people forget to change or update their beneficiaries if there's a change in circumstance, or if they themselves decide they don't want the named person to inherit the item. The lack of the ability to name alternate beneficiaries, it's unfortunately a one and done. So you can't have a list of successor beneficiaries as you can with a trust. Many accounts will not allow you to name descendants per stirpes, meaning that if the person you have named to inherit the item dies before you do, or while you're incapacitated, it will not go to their children, if that's what you would want. There's no control of the timing of distribution. So if you name a grandchild to inherit a car and they are not responsible enough, or if you should never name a minor as someone to inherit a motor vehicle, but if they're not responsible, that would pass directly to them. And there's no mechanism to control use of funds. So if you have someone who has a gambling issue or a substance abuse issue or is in a predatory relationship, and you've named them as an immediate beneficiary on an account, and you die, you can't control the access to those funds by them, even if they're in one of those circumstances where those assets may be at risk. So other assets that require beneficiary designations. These are assets that cannot be titled jointly during your lifetime. Qualified retirement plans, IRAs, pension plans, life insurance. Now, there are second to die policies, so that's the only exception. But life insurance that is usually purchased is in one individual's name. Annuities, stocks, bonds, and CDs. So these would require beneficiary designations of some sort. Real estate. If an individual owns property, either individually or with a spouse, and does not create a trust, I always recommend that they have a beneficiary deed, which is a deed that passes title to the individual or individuals who they name in that special type of deed to inherit upon the death of the last grantor. So if you own property individually, upon your death, your individuals that are named under the beneficiary deed would inherit that real estate. So even if there's a mortgage on real estate, or you do not own it entirely outright, it's not paid off in full upon your death, the individuals you name on a beneficiary deed would inherit subject to the mortgage. So they could sell the property, the mortgage would be paid off, and they would receive the residual proceeds of the sale. Even if someone has a reverse mortgage, I still recommend, unless the owner is certain that there is no residual value, because the reverse mortgage is not necessarily for the entire value of the property. It can just be for a certain amount. So I always recommend naming beneficiaries because they could inherit the remaining proceeds. A beneficiary deed must be recorded before the death of the owner to be effective. And again, beneficiaries can be changed at any time by the owner, so long as competent, or your legal representative under a durable power of attorney. So if, heaven forbid, one of your beneficiaries dies, that can really be problematic, particularly if there's a situation where there's a second marriage and there are not children born of that second marriage. There could be the very unusual circumstance if your named beneficiary dies, and it would ordinarily then go to their spouse unless the beneficiary deed is changed, but their spouse has children that are not children of the beneficiary. It could be a very odd circumstance that the spouse's children wouldn't have an interest or an ownership right if a beneficiary deed is not changed. And the benefit of a beneficiary deed is you do not lose control during your lifetime. So if you decide to sell the property, you can sell it without a problem. It means that the beneficiaries named would no longer inherit it because you don't own it. So consequences of beneficiary designations alone. If the beneficiary named is a minor, or if your named beneficiary is the parent of a minor, and there is a designation of lineal descendants per stirpes, it means that the person who's died, children, no matter what their age, would inherit that asset. And if it is a minor, a person under the age of 18, a conservatorship would need to be opened, meaning someone would have to petition the probate court to have someone to handle that asset. Again, you cannot control how the asset is used by the beneficiary after the death of the owner, if there are those circumstances that I just discussed. If the beneficiary predeceases the owner, the asset will go into that beneficiary's estate. There's no creditor protection, no divorce protection, or estate tax protection. So these are all possibly reasons why someone would want to create a trust. So let's finally talk about this 80,000 pound or 800,000 pound elephant in the room. So a trust, the most common type of trust is a revocable living trust, meaning that it is created during someone's lifetime while they're competent, and it can be changed by that individual, or perhaps if the trust document allows, or that person's durable power of attorney allows, it can be changed within certain parameters as expressed in the document by that person's trustee or the attorney in fact, under the durable power of attorney. You must title and update beneficiaries on each asset in the name of the trust to fund your trust. So creating your trust is step one. Step two is making sure that any assets that can be titled in the name of the trust, like bank accounts, money market accounts, life insurance, can be titled in the name of the trust soon after it's created, to make sure all of those documents flow according to those detailed instructions. Again, certain assets such as IRAs, pension plans, cannot be titled, many annuities cannot be titled in the name of the trust until death. So you would make a beneficiary designation to your trust. It's much more complicated than that, but just by means of example. For a will, you have to have beneficiary designations on all your assets. The will is basically a set of instructions and a wish list for how you want your assets to be distributed for those that lack beneficiary designations. The beauty about a trust is that it becomes effective the minute it is signed and funded. So if you transfer assets into your trust, you can spend your money that's in the trust, use it however you want, but when you become incapacitated, your designated trustee will have the authority to use your assets for yourself and for your spouse. You can provide that instruction. If you have a disabled child or grandchild, you can say that I want my trustee to balance my needs along with those of my spouse and or disabled children or grandchildren. Again, the will is only effective at death, so there's no use during incapacity. So I think of a trust as kind of a blanket that covers incapacity and instructions for distribution of use of assets after death. That's why it is such a wonderful instrument for some people, not for everyone, because not everyone needs a trust. Again, upon death, no probate for assets that are owned by the trust or transferred to the trust with beneficiary designations. And again, I've already talked about this ad nauseum, but creation of a will alone does not avoid probate. The expense of a trust is very often what people shy away from, but it is considerably less expensive to create a trust and fund it properly than going through probate, other than for a small estate. Probate, if an asset needs to be probated, particularly a full estate for assets over $40,000, creditors can file claims for 6 months after the filing of the last will and testament, which can be a good thing because it provides a basically date after which creditor claims are barred. But if all of your assets transfer with beneficiary designations, essentially there is no probate estate to open. So creditors could force the opening of an estate if there's a large enough claim and they deem it necessary to do so. But that's usually an unusual course of action. Any questions thus far? I know it's a Monday, it's a very quiet group. No questions?
Yes, Deborah.
Yes.
Um,
Because most traditional trusts, because they become effective immediately upon signing and funding. So the grantor can handle their assets. When they become incapacitated, there's usually what's called a trigger. So that language that means that states this document shall become effective with my one physician writing a letter of incapacity. Sometimes it may say when my successor trustee, in conjunction with a letter from my physician, determines I'm incapacitated, and then that letter or documentation from the trustee and the physician would need to be attached to the document for the trustees to be able to act. It's pretty unusual for a trust to only become effective upon death, unless it's a testamentary trust created under someone's will, because the whole point of having a trust in large part is not only for distribution and administration upon death, but when that person becomes incapacitated. So it really depends on the terms of the trust.
So therefore, the attorneys in fact must advise the co-trustees of what their actions will be before death. Is that pretty much true? Do the attorneys in fact of the general durable power of attorney, do they have to advise the co-trustees of the trust what their actions are going to be before they take the action?
No, there's no absolute requirement that they do that. If there's any language in the durable power of attorney that requires transparency or disclosure of information, it's usually only among or between individuals named under the durable power of attorney. Because when you're named under a durable power of attorney, you have authority over assets that are not titled in trust. So the trustees have authority over that, those assets, and it would not be duplicative. So the trustees have authority over assets that are titled under the trust, and the attorneys in fact would have authority over non-trust assets.
Like a bedroom sets, for example, the assets, the personal assets.
Personal property,
Yeah.
Correct. But also IRAs, annuities, things like that. But one thing that I do want to discuss is I'm really extremely leery, and I will almost never appoint co-trustees unless a client really insists on it, because I think it is just a recipe for disaster. Financial institutions do not know how to handle it. If there's any disagreement amongst joint appointees, just the utility of the document comes to a screeching halt.
That leads to my next question.
Yeah.
When the co-trustees take action after death, how do you tell whether they can act in majority or must act jointly?
It's all based on what the language in the trust provides.
If the language of the trust does not specifically say acting jointly, would it then go to acting in majority?
Well, do you mean amongst the three?
Yes.
One would think it's either majority or unanimous action. Frankly, I would have to pull case law and see what that interpretation was under case law when the document itself does not specify. That would be a problem. I've got like
Okay, thank you.
minutes. Thank you. Those are excellent questions because they're all extremely important.
We have two hands up, and I don't know if you want to take those questions now or Eleanor and then Barbara.
Sure.
Eleanor, you want to unmute?
All
Eleanor?
right. So if I ask a question now, it's non-billable hours, but if I ask it in our meeting, it's billable, is that? Well, I'm going to take advantage of it today, I think. Got something in the joint tenancy, my son, and it's not in the trust. I just wanted him to get, something extra, and we'll probably discuss it tomorrow a little bit. I just wanted him to get a little spiff because he's, power of attorney, and I just wanted him to, be compensated for the effort that he's going to have to put into taking care of a lot of the paperwork. So is there any disadvantage in not pulling that money into a trust and change the percentages on the trust,
No,
opposed to letting him, just let him take over what it is after our demise?
no. I really recommend that we change the percentages under the trust. If you want to compensate or specifically have that provision that states, I want my trustee to be compensated, X percent. That's not a problem at all.
No, okay, well, yeah, I divided the percentages on the trust, but if we both go, I want him to, just
Sure.
let it go directly to him. So that's,
And we can
that's
do
good.
that. That can be reflected in the trust.
Wow, I got a freebie. Thank you.
You.
Now we have Barbara Becker. Would you like to unmute yourself?
Hello.
Yes, I just want to say that I've worked with Debra on a cousin's estate. She was at the point she was ready to, she hadn't signed any papers, and I had gotten a call for her from your office, and I had to go and find her relatives on her father's side of the family, and it was a big mess. My husband and I have had ours for a long, long time, and it was quite a lot of work to do it. You have to get permission from relatives. If nobody has a living will, a trust, whatever, do it. So there's no problems. And Debra can testify that there was a problem with one of the cousins from her father's side of the family. And it was a pleasure working with you, Debra.
Thank you. Thank you.
And it's
nice to see you. Thank
I
you.
have a question.
Sure.
If the federal government changes a lot of these trust laws, how long does that take? And does the state have more precedence on it than the federal government? How does that work?
It all depends. The federal government has jurisdiction over Internal Revenue Code on the federal level. The states have their own tax laws that pertain to, their own income tax issues. So the federal law can change extremely quickly. I mean, I remember in 2006, this is going back quite a ways, the Medicaid law changed. The law was changed December 6th of 2005, and it became effective on January 1st, 2006. And boy, there are a lot of late nights. So federal law can change very, very quickly. State law can too, but state law becomes, at least in Missouri, becomes effective on August 28th. And the end of the legislative session is mid-May in Missouri, and it all depends upon when the governor signs a bill or does not sign a bill into law. But it can change very quickly.
Janice, Janice had a question, and you want to unmute yourself and go ahead and ask your question?
Yes. So we have two children, and having gone through a situation where we've had co-trustees for a parent, we have just one trustee on ours, but the successor would be our other child, who is much less capable as far as finances. She's our healthcare power of attorney, but financially, she's not really, I believe, as competent. So is there any person that you could put with her or instead of her that would be not a relative or anything like that, that could become a second successor?
Sure. So there's always corporate trust companies that can be named, but there's definitely a cost that comes with that. But very often that is an option that people want to avail themselves of if they have concerns such as this. Also, there are attorneys, there are CPAs that can serve and that will do so. I think that, frankly, someone should never, the person who's drafting the documents should never name themselves in the document as a trustee, just because I think, it is rife with potential conflicts of interest. But I think there are good reasons to appoint a third party if you have concerns about someone that you feel just it does not have that acumen, or maybe can't be trusted or timely. The other thing is you can write in the document that you want them to use a financial advisor that you designate, or a financial advising company. And now financial advisors cannot serve as co-trustees because of the regulations pertaining to their industry. But you can always have, there's also the concept of a trust protector that can monitor transactions in excess of a certain amount, can potentially review transactions each quarter, or however frequently you want them to do that. That gets beyond the scope of this talk, but there are definitely options that you have.
Okay, it's not that I believe she's a spendthrift or,
Oh, sure.
anything like that. It's just that she's
Not her
just
skill set.
doesn't have financial knowledge,
Sure.
and is not that organized of a person.
Right.
So,
Right. I understand.
and I think that the financial institution like a trust companies we've looked into that. It's kind of cumbersome. And so I was thinking more of that's maybe the financial advisor person or accountant or something like that would be easier to work with.
Good. I'm going to
Okay.
actually ask that I take no more questions right now, just so we can get through the rest of the slides. I'll take them at the end. Thank you. They're all excellent questions. I appreciate it. So there are different types of trusts for different purposes. The most common by far is the Revocable Living Trust. The beauty of this document, and again, it's not for everyone, but that it allows you to be very descriptive in how and when and under what circumstances you may want your beneficiaries to inherit assets. Obviously, if you're leaving everything to charity, frankly, I don't see any need for a trust necessarily, unless you have some more complicated provisions. But if you're leaving assets, particularly if there's a special needs grandchild or child, where you want to make sure that their public benefit eligibility is not going to be jeopardized, you may want to leave assets under a special needs trust provision. It's either in your personal living trust. I also include a special needs trust in every will and every trust I create, because you never know when someone may become disabled and in need of public benefits. So that's kind of a safety net. But if you are concerned about someone who may not have excellent financial acumen, or be a spendthrift, or have a potential substance abuse or gambling addiction, or maybe concerns about a divorce or a predatory relationship, again, a trust of one kind or another would enable you to have the trustee be able to hold back distributions until that circumstance was no longer in place. Also, if you are concerned about an adult child dying and they have minor children, you may want to create a trust so that if their share passes to their minor children, you've provided for a trustee to administer and hold those assets under whatever terms you want for your grandchildren, so they don't get that inheritance immediately at age 18, which they would otherwise do if they were just named as a beneficiary on an asset, or if you had a will that provided that a specified individual's children would inherit if they predeceased you. Irrevocable trusts are another type of trust which is less common, that is used often with regard to asset preservation. Testamentary trusts, again, are trusts that are created in a last will and testament. They only come into being when the last will and testament is filed with the probate court, and that is when the assets would go into that trust based on the beneficiary designation on the account to the Debra Schuster Testamentary Trust set forth in the last will and testament dated today. Special needs trusts we just discussed a little bit. There are life insurance trusts which have tax advantages that are beyond the scope of this discussion, and charitable trusts. There are many, many types of trusts. And I would say the Revocable Living Trust, the Testamentary Trust, and the Special Needs Trust, along with life insurance trusts, are potentially the most common. So property is transferred to the trustee of the trust and is governed by the terms of the trust agreement. So when you create a trust, you are usually the first named trustee. You have complete, authority to use your assets however you want, income and principal. You can drain your trust, you can do whatever you want. If you become incapacitated, and that's when the authority transfers to your successor trustee, it doesn't mean that the asset is owned now by your trustee. It just means that your trustee is acting in that representative capacity, a fiduciary capacity for you, meaning that they have to safeguard the assets in the trust. Actually, under any financial instrument where someone is appointed, if they serve, they are responsible for acting prudently as a reasonable person would do to take control, not waste assets, not let them become spoiled or destroyed or abandoned, unless under certain circumstances that is allowed in the document. But they are to be a good financial steward, a fiduciary of your assets, and to use those assets specifically only as allowed in the document. So the grantor or the trustor or the settlor is the person creating and funding the trust. The trustee is the person or entity named to handle and follow the instructions contained in the trust document. And again, it could be an individual, it could be a corporate trust company, it could be a third party. And we just talked about the types of trusts. An irrevocable trust is used primarily for asset preservation and public benefit preservation because it cannot be attributed to the beneficiary. When it becomes irrevocable, it's either because the grantor has become incapacitated or has died and cannot be changed, again, based on the terms of the trust, or for asset protection and public benefit preservation. Usually that document becomes irrevocable upon signing, because then public benefit programs and other certain tax provisions would not be able to consider those assets as owned by the grantor. So assets passing in trust can be as flexibly or subject to limitations as you wish. Again, the beauty of a trust is you can have very detailed instructions. You can say, I want these assets, if they're transferred to my grandchildren, to only be used for education, and specify what educational programs you will and will not pay for. You can specify that you want it to be used to start a business, to pay for a down payment on a house. You can keep assets in trust for the duration of someone's lifetime if you want essentially all income to be used for an adult child, and you want the principal to pass to grandchildren. The trustee must follow the instructions that you put in the trust. And the trustee only, again, has authority over assets that are titled in the trust when it's created or that are payable to the trust upon death. So we're running out of time, but this is how these assets would work. Property in your name, money, real estate, stocks, bonds. Some vehicles, I don't usually recommend that vehicles be titled in the name of a trust because people usually get vehicles more, purchase and sell them more frequently. Personal property, absolutely. Jewelry, all of those things can be dictated by the terms of your trust, transferred into the trustee's name that can pay, and the trustee can then pay income to you or use it for your benefit. Again, give you as much principal or use as much principal as necessary for your needs, and follow any other instructions during usually your incapacity. And then after your death, to transfer whatever of those assets you specifically identify to be transferred under the terms of your trust. An irrevocable trust, again, can be used for all of these issues. And again, you're going to be getting copies of these slides. So what do you do with your documents once they're signed? Keep original documents in a safe place, a fireproof box or safe. I am not a fan of safe deposit boxes, especially having gone through COVID and seeing how difficult it is to access safe deposit boxes. The other issue is that with banks and financial institutions acquiring one another, there's no inventory that is done when banks acquire other banks that have safe deposit boxes. So there is a huge lawsuit going on in New York State with an antique watch dealer that stored very expensive antique watches in a safe deposit box. And when he went to sell 2 of them, they were gone. So there's a multi-million-dollar lawsuit. And so I'm not a fan of safe deposit boxes. Give copies of these documents to your named appointees so they know what your documents say and when their authority begins. Verify on a frequent basis that your named appointees remain willing and able to serve. And give appointees the information they need to handle your assets if you become incapacitated. You know, where those titles are, what credit card accounts, if there's any loans outstanding, all of the tools that they need to handle your assets. The more you empower them and give them the information you need, the more useful your document will be. And finally, review your estate plan every 3 to 5 years. Whenever there's a change in significant life events, retirement, birth, death, divorce, if you move to another state, review those documents. And then if you have no major life changes, still review them every 3 to 5 years to determine if you still want the appointees you've named and if they're appropriate, and to review the disposition scheme that you have for your assets. And finally, for any changes in law. So, any remaining questions?
You want to stop your screen share, screen share, and we can see the full screen and see if we have any questions.
So, let's see. Screen share. That work? There we go.
There we go.
Hello, everyone. Thank you.
So I want to thank you, Debbie, very much. This was a lot of information to digest, and I can send everyone the PowerPoint. I also want to thank a special thanks to our co-sponsor, St. Louis Senior Colel. Administrative Director Linda Markowitz is here and would like to say a few more things. You need to unmute. Thank you so much for co-sponsoring and being with us today.
Thank you so much, Deborah, for a very informative program, and thank you for allowing us to partner with you on this very important subject. Just 1 minute about the Senior Colel. We're a division of the St. Louis Colel. Our division is strictly to assist in the physical, emotional, and spiritual needs of the over 50 crowd. And we have a website, stlcolel, KOLLEL.com, if you want to check us out and see all of the great things that we're doing for the over 50 crowd. Thanks again, Deborah, for a great program.
Thank you so much. Thank you all. I appreciate your time.
Thank you, Deborah, again. And thank you everyone for being here today. And if they have any questions, they can, if anyone has any questions, you can send them to me and I can forward them to Debbie, and she can either directly respond to you or can I share your email address,
Oh, yeah,
Deb?
it's on the slides.
Okay, okay, great,
Yeah.
great. Okay, so thank you, everyone.
Take care.
Have a good day, everyone.
Thank you.
Bye.
Bye.